in its opinion, said that first of all, what was being asked was kind of pulling together all of the responsive information and turning it over to the government. And the court said that was not a search, and it was not an illegal search. But the court went on to state that if DAS was in fact required to go through these private emails, the court would not find that a Fourth Amendment violation either. And the reason why these supplemental documents are important is they establish three things. They establish that there is no controversy that these were in fact never intended to be archived by the state. Number two, that they are his personal emails. And number three, that the state of Oregon is in fact not reviewing them. And that information, I believe, is very important to the court's finding.
Not reviewing them. I'm sorry, what do you mean by not reviewing them?
Right now, the state of Oregon is simply holding the 100th Meridian account. It is not going through those emails
for the purpose of producing them for the subpoena.
They're not going through them for any purpose. They're not going through. We attach to you the Oracle pleadings that the state.
In general, what's happened, by the way, the state of Oregon is, everything's on hold because of the motion to quash, and there has been no production.
There's been absolutely no production.
Has the state ever taken any position on this? The state, the office of the governor, or the executive, or any entity of the state of Oregon?
The only official position that the state has taken on these documents is the Oracle litigation pleadings that we've provided to you, where they have said that it was inadvertent that we have them. The governor, former governor, asserts a privilege, and we're not going to go through them. And, Your Honor, if you want us to go through them, you're going to have to resolve this.
Since they didn't take that position, I assume it's too late for them to do that. Is that right?
I don't think the record shows this, but we filed a motion to quash. Everyone knew we filed a motion to quash. And I believe that because it was in the Oregonian, it was public knowledge, the state has waited. I cannot and I am not privy to what arrangements the state's worked out regarding other documents.
At the outset, I think it's important to note that this was not a subpoena that was issued to the former governor for his personal emails. It was a subpoena that was delivered to the state archivist seeking public records. Now, this particular subpoena, like many subpoenas that we issued to third-party, or I should say non-party custodians, included a temporal request. We want all information relative to these dates. So the list that was included with the subpoena itself was to give notice about the nature of the investigation and no more. Judge Hernandez properly considered that and considered our enterprises, the role of the grand jury in seeking material in upholding this particular subpoena. Now, the privacy concerns that have been asserted here, again, it's by someone who is not the recipient of the subpoena. Henry Horn is completely off point. That was a subpoena that was directed to a criminal defense attorney. There were some obvious concerns about overbreadth because most of the items sought were covered by an attorney-client privilege. We simply don't have that here. And our issue is really more tailored to there is no reasonable expectation of privacy in material that has been stored with the state archive.